Just one.
There are two other petitions from the Gujarat High Court.
You can mention yesterday's number. It will be so much easier for us, so we have just.
501.15 months.
4 and 1. 14 and 15 are connected, right?
There are three petitions, I believe, my lords. Soumya and others, 𝐀𝐓𝐕 14, 15, and 16.
Thank you.
That 14, you are appearing in 15.
Yes, my lords.
So chief doesn't.
My lords, at the outset, I must say that there is a difference between the matters that were argued yesterday and my matter, in so much so that the question of the reference of 𝐀𝐓𝐕 is not directly involved. The common link, of course, is that there is illegality involved that we are
So then
challenging.
why should we'll send this back to the two judge bench.
Your challenge here is basically on the ground that Shetty Commission as well as All India judges says the cutoff should not be imposed at all.
Yes, my lords.
That's the point.
Yes, ma'am. And my lord, what has happened?
That's not the issue for a difference.
That is why it is my role, my lords, as an officer of the court, to
Some
mention
of them are saying that.
that it,
won't be covered by the.
Gujarat matters, you are saying the same thing, right?
that is right, my lords.
Then the point was whether the
There is a right
whether the
impose
right to
cutoff.
impose the cutoff at all in view of the judgment of in view of the Shetty Commission report and the judgment in All India Judges Association.
The only difference, my lords, is that subsequent to the Shetty Commission, where a specific direction was given to all the states to implement, the Gujarat High Court in the year 2005 had in fact amended their rules in terms of the All India Judges
In
Association.
your case, the rule itself in 2011 provides for a 𝐀𝐓𝐕 test of 40% and a cutoff.
That is right.
Which will challenge the
That is
validity
right.
of that. Whatever.
So this does not arise before the Constitution bench.
I appreciate that, my lords. There
Right.
is a difference in the question, but we are still challenging it on grounds of illegality, and there's a
That's
judgment.
regular.
May I just have 1 second, Lord? I'm appearing for the High Court, my lords.
Yes.
Lord, these rules were challenged, carried it up before this honorable court, and SLP was dismissed. I must point that out.
That you will mention before.
That you can mention before the regular bench, actually.
Very well.
And Millard, then you should kindly consider whether this should go with Salam Samarjeet, which was referred by Lordship yesterday to the three-judge bench, or these matters should go to three.
Because there is no difference of opinion here. That Samarjeet was because of the
But
difference of
Miller, exactly the same issue again. Salam Samarjeet was again on the same issue.
Oh, I see.
My lords, the
Referring to a three-judge bench. But the thing is, the moment I say three-judge bench,
Something else.
and what will happen is it will take a little more time. If you go before a two-judge bench, you'll get a bench hearing immediately.
2022 appointment.
That is the reason many
Four
in many cases facts would have led to the dispute being resolved. We don't really know. These are 2005 rules and 2019 is the advertisement. So therefore, let it go to the two-judge regular bench.
That
And
bench
if they
can
want,
make
they
a
will
call.
refer to the- or else-
As a lordship.
Because despite holding in favor of the petitioners in the other case, just because of passage of time, we've got relief. So it's better that you should try and get a.
That is what we're
opportunity.
trying to beseech, that even in these cases, there's
Therefore,
illegality.
Strategically, two judges bench should be the option for you.
I
You
appreciate
are appearing in which matter?
it.
This.
So whatever you
That can be.
argue.
The learned counsel appearing on behalf of the petitioners, Gujarat wale matters mein, the learned counsel appearing on behalf of the petitioners are agreed in stating before the court that the issue which has been raised in the reference to the Constitution bench in 𝐀𝐓𝐕 𝐍𝐞𝐰𝐬 Pura Naam Le Lo does not arise in this batch of cases. Full stop. Hence, it has been submitted that the matter may be placed before an appropriate bench for disposal. Full stop. Mr. 𝐀𝐓𝐕 𝐍𝐞𝐰𝐬, appearing on behalf of the Gujarat High Court, also has no objection to this course of action. Full stop. Hence, these three petitions shall be dealing from the batch of cases before the Constitution Bench and shall be placed by the registry before an appropriate two-judge bench for taking a considered view of the matter.
My lord's only request is for it to be agreed listed matter.
The registry shall do so within a period of 2 weeks.
Regret the opportunity of appearing before your lordships.
I was also thinking that you would appear and argue. This is a very interesting point to argue.
My lords, I didn't have it. Thanks, my lords.
Now, which is the next lot?
Guwahati.
कल केरला हो गया था ना? गुवाहाटी हो गया, मणिपुर हो गया, केरला हो गया.
गुजरात का प्रॉब्लम ना.
Manoj, Guwahati.
You are appearing for Guwahati. There are three matters from
Yes.
Guwahati.
Guwahati.
Guwahati is 501.2, 501.3 and 501.11. Yes.
Advertisement.
Manoj, in my case, like Mr. Mukherjee had pointed out yesterday, the rules which are there, the Assam rules were implemented in Manipur.
Yes.
So the same rules apply to my case. Now, allow me to.
So should this follow the same course as
No,
Manipur then?
No. I'll tell you why, Manoj. In Manipur's case, on the 12th of January 2015, the full court takes a resolution. Thereafter, that resolution is communicated to the petitioner therein, not the resolution, pardon me, the fact that he has been called for a viva voice. In my case, what happens? I'll start from after the viva voice, Manoj. The notification for advertisement was issued on the 18th of January 2011, which is, Manoj, it's annexed.
Take the dates from you in a minute, but
Yes.
just give us in
Yes.
in
In a
1
nutshell,
minute
I'll
just the
tell you.
essence of the matter.
Just the 3 dates you just give
Yes.
us. Advertisement.
Manoj, advertisement
and
is
amendment.
18th January 2011,
You are in 501.2, right?
501.2, Vishwajit Prasad versus Guwahati High Court. 2, 3 and 4, Manoj, connected, same matter.
Yes. You are appearing in all three.
Yes.
And 501.11. Mufida Haq versus High Court.
Yes.
All right, tell us the dates. Give us the dates. So that we can-
Like I said, 18th January 2011, when the advertisement was published in terms of the rules then prevalent, which is the Assam Judicial Service Rules 2003.
Rules 2003.
Yes, madam.
Yes.
Because thereafter, the preliminary examination, I'll not give that, that's not really important, but I'll come straight to the viva voice. My lords, on 29th of October 2011. My lords, now this is where the difference starts. Now, the rules say, which Mr. Mukherjee had shown to you yesterday,
Complete the dates so that.
my lords, 29/10/2011 is the viva voice, and the select list, which is the final list declaring the successful candidates, was published on the 1st of December 2011. So this entire process took a period of 12 months, right from January until December.
Right. Right.
My lords, now the only difference in my case is that after the viva voice was concluded, by way of the rules, it was prescribed that they ought to have published the cumulative grade list, the merit list. Now, in my case, there was no merit list which was published at all. So when the results were declared on the 1st of December 2011, they only published the names of those 5 candidates out of the 19 candidates who were called for viva voice to be selected for the grade 1 services.
When 5 candidates notified.
Yes, Manoj. Now, thereafter, I approached this honorable court by way of a 32, which was withdrawn with liberty to go back to the High Court. I then go back to the High Court by way of a fresh writ petition, Manoj. Now, in that writ petition, prior to that writ petition, I also filed RTIs. Soon after the results were declared, which is 1/12/2011, I filed RTIs on the 7th and 9th of December 2011, seeking the information of the marks obtained by each of the 19 candidates who appeared for the Viva Voice after having qualified the mains examination.
So Viva was conducted for 19 candidates.
19 candidates.
Yes.
My lords, now after I sent my RTI, after the declaration of the result, we were hopeful that the RTI would disclose the marks, but the RTI came to be rejected after a period of 1 month, which is a statutory time.
Right.
Thereafter, my lords, like I said, on the 13th of February 2012, I approached this honorable court under Article 32, but that petition was withdrawn with liberty to go back to the High Court. Thereafter, I go back to the High Court in July 2012 by way of a fresh writ petition. Now, my lords, this is where the interesting part comes in, that until now, I don't know what my marks are, what I have obtained either in the mains or in the Viva.
Yes.
Now, before the High Court directs on the 8th of November 2012 that you please disclose the marks to the unsuccessful candidates who were petitioners before the High Court. So then by way of a letter which was issued to me by the High Court on 9th of November 2012, the marks were disclosed to me. My marks, the unsuccessful candidates and the 5 petitioners who basically approached the High Court.
Yes.
My lords, now after the marks, my marks are disclosed to me on the 9th of November, the High Court files its counter affidavit before the High Court on the 26th of November. My lord, if I may be allowed to read 2-3 lines from that counter affidavit.
Just tell us orally.
Tell us orally.
Yes, my lords, in that affidavit, the High Court says, citing the rules, and I'll take you to that rules, which my lords had rightly pointed out yesterday that it's not for interview, it's only for cumulative marking on each questions of written examination. But the High Court says that they had the power under the rules and they have exercised their discretion rightly. While
What?
in the counter affidavit, they say that by prescribing a benchmark of 40%, there has been no error in jurisdiction committed by the High Court.
No, what they say is 25th of November, they have passed a proceeding.
Yes,
We didn't get that. 25th of November is the decision which was taken
yes,
to prescribe a cutoff.
yes,
That is what has happened.
yes, ma'am.
25th November.
Was conducted on after the Viva was.
After the Viva.
That's the crucial.
25th of November.
25th
2011.
The proceedings. You can. So that you are saying post-interview.
Post-interview, my lords, they have introduced a benchmark and they have said they've exercised their discretionary power while exercising that benchmark. Now, my lords, without getting into the judgments and everything, we are not challenging the power of the appointing or selection authority to fix
The bench.
any minimum marks that they can fix. That's a matter of policy decision. What we are challenging, which is why I say that we fall under the reference, is because those rules were made applicable after I played the game, after I participated in the interview.
Yeah, 25th of November.
The reference clearly arises here.
Yes, my lord.
If I may clarify, there is a factual error. I'll point it out once.
Just tell us in a second. I mean, we can.
Cutoff mark was fixed for language paper, paper 4, not for Viva-Voce.
Correct.
So when was it fixed?
It was fixed later, but as far as the
Give us the
25th
date.
November.
25th November, right?
No.
When was the cutoff for the language
It is
paper fixed?
prior to the Viva-Voce, because only those who scored
Just give us that.
Crucial point.
Yeah, that's
This
the
is what
most
you must
important.
specific date it is coming, because the rule
So
doesn't.
just give us the date. He will agree with that. Show us, because on the record there can't be two differences.
No, that's what I'm saying. The date specifically is not on record, but it is prior to Viva-Voce. Because
That's
unless
what you will have to demonstrate to us. That it
That-
is
that-
correct.
it
Yeah.
is there in the page what this reply before the High Court. It says 40% cutoff mark was fixed for language paper.
Is it correct that the cutoff was
No, no.
fixed for the language
No.
paper only?
No, allow me to clarify, my lord.
All right, we'll hear you later. Yes.
Allow me to clarify. My learned friend has rightly pointed out this thing, but allow me to clarify. There were 4 papers for written examination. Paper 1, paper 2, paper 3, and paper 4. Paper 4 was the language paper. Language paper was only a qualifying paper, which is in the Assamese language for the state of Assam, because since grade 1 officers will be operating in the district judiciary for the local language. Now, my lords, para 10 of their counter affidavit before the High Court, that paragraph has to be read as a whole, and preceding that para, they deal with the language paper. Para 10, they say that with regard to the statement made in paragraph 9A of the writ petition, I say that by prescribing a benchmark of 40% in the paper 4, the High Court has committed the High Court had not committed any error in law or jurisdiction. Now, this is the interesting part. The selection authority has always discretion to fix its own standard of evaluation, and the High Court has exercised such discretion. No discrimination or arbitrariness has been directly or indirectly done therein. A written examination is not sufficient to assess overall intellect and personal quality of the candidates, which can be done at an interview only. So, my lords, this benchmark of 40% could not have been fixed for the language paper, because if you read the counter affidavit before the Supreme Court,
So they seem to have done it for both.
they seem to have done it for both. And in any case, my lords, the language paper is a qualifying paper. That doesn't add to my marks while calculating the cumulative grade list.
So you have no problem that they fixed a benchmark of 40% for the language paper.
My lords, this statement is actually,
You have cleared the language paper.
yes, which is why I was,
So that's irrelevant for you.
that's irrelevant.
But then, therefore, you are claiming that, well, apart from the 40% benchmark for the language paper, they also fixed a qualifying cutoff for the viva voce.
For the viva voce, which is evident at para 10 of the counter affidavit filed before the High Court, which I just read out to you, my lord.
But it can't really be a matter of averments in the pleading, in the affidavit. I'm sure there will be a proper decision taken as to whether it is intended for a benchmark for the written exam or viva or what.
Finding we need to see.
No, you must check up and tell us. It can't be, don't say that I have the file with you. Tell us what the file says.
For paper 4 is language.
So there was no benchmark, there was no cutoff for the viva?
No, the cumulative mark was taken. They scored much less. That was their grievance. They scored, all of them scored less than 10 mark out of 50
In the interview.
in the interview. Total of both 3 papers plus the interview viva was together, they were all below the selected 5 candidates.
Then they're out then, if that is so.
Show us that.
Show us that, show us the relevant file then. We'll just look at it, we'll look at the record, then the reference.
A matter of controversy, actually.
Because he says that as a High Court, that we never fixed a benchmark for the interview. Now, maybe they said that in the para, but it's a matter of record. It can't be a matter of the counter. Let's just see it. Just have you flagged it? Have you flagged the relevant part? Don't make us go through the whole file now. एक मिनट उन्हीं को दे दीजिए, वो flag करने दो। ये क्या है?
This is a judgment. No, this is a full court. This is exactly 25th November. This is what we were to see.
All right, let's just see quickly.
Correct. This was not there on record. I was looking for this. Correct. This is exactly relevant portion.
The 4th page. 3rd page, at the back seat.
Yes.
The marks are there, as on the district. This is the committee report. This was approved by the full court.
Have they imposed cutoff? It doesn't say that they have imposed cutoff anywhere. But they are saying that they have the power to do it and all that.
In the first page, they say as well as
Yes,
17.5% mark out of 50 in paper 4 at the last line. Called for interview and viva voce.
So Jose, the 5% at page 7.
Yes, ma'am.
They are all in seriatim with the highest aggregate
Yes,
score.
they are all 5 in serial.
That's what I noticed.
I have calculated it here, my lord. It's all of them are above the petitions.
Jose, it appears
Yeah.
that you have also added the marks of paper 4.
No, that's here. Here it is added, but I have.
He says, for minimum prescription on the basis of which he was excluded. That doesn't seem to be there.
There is no decision. There is the rule provides for suitability. So those who have not.
But contrary to what you are saying that, we never took the marks of paper 4 into account.
Right.
You have to only qualify. You have added the marks of paper 4 also.
No, that is for the here, but the total calculation it has not taken into.
No, but see this. See, if you can go to page 4, for instance.
Yes.
Right,
Abhijit Bhattacharya is the first candidate.
right.
Just a test case. Now, if you see,
First 3 papers total 188, my lord.
now just see Pranjal Das is the first one who gets 284.25, right?
About 11th or 12th item there. Pranjal Das.
Kanchal Das, right.
He is the first one in merit aggregate. Let's just calculate his marks.
Sorry, my lord, on page 4 only.
Page 4, the chart.
Pranjal Das is the highest candidate,
Yes.
284.25. Abhijit Bhattacharya,
Right.
who gets 257. 257 is the total of 74 plus 67 plus 47 plus 29 plus 40.
That's right.
So you added the marks on paper 4 also.
No, that's what is making a statement, my lord. But
All right, then
total of first 3 papers and the interview comes to 228.
228.
228.
Okay. So
If I can just say who are all the selected candidate, the marks, my lord.
the first selected candidate was Pranjal Das, right?
That's right. That's right, my lord.
So who gets 81 plus 74 plus 56 plus 42 points?
That's 253.25, my lord.
Okay,
Total of 3 plus 1.
okay. Likewise, for all the other candidates, selected candidates, you only took the 3 papers plus the interview.
That's
So you didn't apply a cutoff in the interview at all.
the interview. There is a suitability clause.
But did you say that you must get a minimum mark
No,
in the interview?
No, it was not stated. At least on the record, it is not there. Because all the 5 persons who are selected are above those who are petitioners here.
Oh, I see.
On total of 3 plus
And
1.
none of them were rejected on the ground that they didn't get 40% in the interview.
No, that's not at all.
It is not borne out of the record.
In fact, the
Yeah.
page
Just see page 6.
Page 6, the
Let's
top
read that.
paragraph.
Yeah.
They went by Schedule B instructions.
That's right, Schedule B.
Schedule B instruction, that paragraph we read, the
read
top
that Schedule
paragraph.
B, my
Yeah,
lord.
it says in other words, the
Yeah.
selection has to be made on the basis of the aggregate marks secured by the candidates in the written examination and viva voce.
No exclusion.
There's no exclusion. There.
So if there is no exclusion, what's?
Then the
point?
reference doesn't arise here.
Kindly have para 20 of the judgment passed by the High Court. What they
But
say
you
there.
make your submission, no? They
Now you
should-
show us, we've got the record now.
My lords, para 20 of the judgments clearly says that because the petitioner's hearing did not obtain 20% marks in the viva voice, therefore they were found suitable for appointment.
Unsuitable. you know.
Unsuitable, sorry, my lord,
Right.
stand corrected.
No, but that's not
My lord-
so. We've got the record now.
My lord, the point is that this,
Whatever
this,
the High Court said in the judgment,
my lord, this record which my lord has produced, this record was never made available to me, number one.
have a look at it for 2
No,
minutes.
these are proceedings. Actually, the whole
These
thing,
are official records.
the whole thing turned on your argument that the proceedings that took place on 25th of November 2011
Yes.
were post-interview, and during that, by virtue of these proceedings, an imposition of cutoff was imposed. That's the only point to bring you within the ambit of the reference.
This petition.
Well, but
That
then,
is,
but then
so we have seen this.
Dismiss the petition. No point in sending these back also
There's
because there's
nothing
nothing
in
in
this
this.
my lords may kindly appreciate
And
one thing.
2011 advertisement, you have to make out a case, 2011 advertisement, and matter has been pending under the assumption that they have imposed this. We have seen this, there's nothing in this.
There
No,
were
the
two
High Court-
further selections afterwards.
We'll close this, I think, now.
We will-
All right, chalo. This is a selection to, again, the district official.
Grade one, grade one.
Grade 1 service. You call it grade 1 in Assam,
Direct.
right?
My lord, may
and-
kindly.
And the rules are the Assam Higher Judicial Service rules
2003.
of
2003.
2003.
All right. The selection in this batch of cases, the selection which is in question, the present batch of cases, is to the grade 1 service of the Assam Judicial Service, which is governed by the Assam Judicial
Judicial Service
Service
Rules 2003.
2003. Full stop. Next. The relevant dates for the purpose of evaluating the merits of the petitions are as follows. Colon. 1. The advertisement on 18th January 2011, the advertisement was issued under the Assam Judicial under the rules of 2003. Full stop. This was followed by the consisted of
Three papers.
three papers and 4 papers, full stop. Of these, the 4th paper, into brackets, paper 4, was for language proficiency for the region, full stop. On 29 October 2011, on 29 October 2011, the Viva Voce was conducted for 19 candidates, semicolon. 3, on 25 November 2011, the Committee for Recruitment of Judicial Officers conducted its meeting for selection of candidates for direct recruitment to grade 1 of the Assam Judicial Service, Tripura Judicial Service, and Mizoram Judicial Service for 2011. ये तीनों का था. 4. On 1 December 2011, a select list of successful candidates was published, in which 5 candidates were notified to have been selected. After withdrawing a petition which was filed before this court under Article 32 of the Constitution, the petitioners moved the High Court in a petition under Article 226 of the Constitution. Full stop. During the course of the court directed the disclosure of marks, following which marks were disclosed
Only of the unsuccessful candidates.
to the unsuccessful candidates who are before the High Court. Full stop. Next, the submission which has been sought to be urged before this court is that you lost before the High Court, right?
I lost.
The petitions failed before the High Court. That's my understanding. Full stop. The submission which has been urged in the proceedings before this court is that after the interview was conducted on 29 October 2011, a cutoff of 40% marks was prescribed by the Committee on Recruitment on 25 November 2011. Full stop. In order to support the submission, Learned Counsel relied upon the counter affidavit which was filed before the High Court. Full stop. in order to obviate any controversy on the factual aspect, the learned counsel appearing, Mr. Jose, appearing on behalf of the High Court, has placed on the record copies of the minutes of the proceedings of the Committee for Recruitment of Judicial Officers held on 25 November 2011. Full stop. The submission which has been urged on behalf of the High Court is that that paper 4, which was a qualifying examination for language proficiency, in which a cutoff of
17.5 mark, that is 35%.
of 35% was adopted. Full stop. The minutes which have been placed on the record make it abundantly clear that no cutoff was prescribed for the interview, and the merit list was drawn up on the basis of a cumulative aggregation of the marks which were obtained in the 3 papers of the written test and the interview marks.
My lords, if I may, I really apologize, my lords. If I may just say this, my lords, merit list was never published.
No, we are saying merit list was drawn up, we are saying. In view of the above factual background, the issue which was sought to be raised in the reference to the Constitution bench in 𝐀𝐓𝐕 𝐍𝐞𝐰𝐬 so and so would not arise in the facts of the present batch of cases. Full stop. The petitions are according to this.
My lords, if I may kindly say one thing, not on
उसके
the
पहले
merit.
ये भी लिख लो, एक और लिख लो. The selection in the present case pertains to the year 2011. Full stop. The officers who were selected in pursuance of the selection process have already taken charge.
There were other
The High
rules
Court
and-
has also apprised this court that subsequently 2 further selections have taken place in the state for the state judicial services. Dismissed. That's all right. Chalo. So now we are done. वो मेरा ये भी दे दो. So now we are done with
My lords, if I may just say,
yes.
my lords, I agree that I am out of the reference, so I really don't have much to say. But my lords, the only thing which I can say before my lords is that my lords have themselves held in number of judgments, like in state of Jammu and Kashmir was a district bar association, which is judgment written by my lords. My lords have clearly written that an important requirement of public appointment is that of transparency, my lords. My lords, in my case,
You're undoubtedly right that they should have told
lords,
candidates.
I bow down to what my lords are saying.
No
I
doubt.
only say
The
this.
question
my
is
lords,
that you will not get any relief at this stage because the whole basis of the petition is now that we have verified
my lord,
it.
I only say that when this rule of law is, when my lords are adjudicating upon this, my
Transparency
lord,
would mean now, look, we can't, in a 2011 selection, we can't set aside a selection on the ground of a lack of transparency, provided we are satisfied that the merit list was drawn up properly, which is what is found from the record.
Otherwise, go to the next.
We'll go to the now. We'll go to Patna now.
Patna. This is even worse.
Right.
Yeah,
So, what your lordships indicated that your lordships thought, what I thought is I put my submissions in 5 pages, though these issues don't arise, but since your lordships thought if I could assist your lordships on these 2 issues, I thought I'll just put it down, and I'm sorry, it's just hard copy because I just.
Okay. No,
This lordships have it.
but we will now first see the facts.
Whether it will arise or
Does it arise?
It arise at all. I said yesterday.
It doesn't arise.
moderation.
For the evaluation process.
It doesn't arise at all. I said
Process
yesterday.
That
but
has
it's a
been
lordships.
challenged in the writ petition.
You have not.
But
The
what I
issue
was-
is not arising in the present matter.
But in my respectful, but the 𝐀𝐓𝐕 reference also doesn't arise. That's what I thought.
Yes.
I have tried to figure out if a lordships is.
Now just
I'm
tell us,
in the
here, just tell us in like 2 minutes,
Yes.
what are the facts here? So we'll see if there's any substance. If there's some prima facie point to be argued, we'll send the petitions back to the
I'm very
two-judge
grateful
bench.
for that. I'm very grateful.
Otherwise, there's no point in just prolonging the agony of these candidates further.
Yes, Avinash Kumar.
Avinash is 501.1.
Yesterday.
The advertisement in this case was published in 2015, in January 2015. Yes, please. The advertisement was published in January 2015. No? This was a district judge entry level, direct from bar examination 2015. On 22nd March 2015, a screening. Today it is 501.7. Yesterday it was 501.1.
Yes.
This is writ petition 165 of 2017. Madam. Yes. Madam. May I please.
Whether it falls within the reference or not. If it doesn't fall, we will protect you. We will not state
Yes.
unless it's so.
Unless it's so obviously
Obvious
that
that
we don't
that
have to
is
send
there.
it back before.
Tell us those.
Just give us a few, 3-4 dates, that's all.
Yes, this advertisement was published in Jan and then
Correct. Jan of
March
2015, right?
Screening tests were taken. So where I qualified in the screening test,
When was
Then
the
the-
screening test? Sharman?
22nd March.
22nd March 2015. Written examination was conducted on 12th July 2015. But I obtained 127 in the written examination. However, the qualifying marks were 125.
You got how many marks?
127.
Qualifying were 125.
Yes, madam. So,
So you qualified.
but I was not called for interview.
Yes.
The total 81 candidates were called for interview. Madam. Later on, that list was also shuffled and then 5 candidates were dropped from there, 2 added later on. So this was some juggling up. So ultimately, I filed a RTI application on 18/4/2016 to Patna High Court, seeking a copy of my answer sheet for paper 2. Paper 2, I had obtained 53 marks. So in paper 2, Milord, when I was given the answer sheet in the first week of July 2016, so I had received 0 marks in answer to question number 8, 10, and 23. So there were several limbs of the question which were answered by me. So in a corresponding to this question number 3, another candidate was given on the same answer 5 marks. So I was
Given
just
0 for questions 8, 10, and 23.
8, 10, and 23.
Right.
So there were several limbs, 3, 4 limbs in the question.
What's the grievance now?
But I sought re-evaluation.
That's it.
The High Court said there is no rule to provide you re-evaluation.
So that's the issue.
That's the issue.
That's the issue. Re-evaluation is the question.
Yes, ma'am.
Why this is stuck? So it's not a case of cut
Now,
off.
where is the right to revaluation?
Yes.
And moreover,
Sanjay
moreover,
the
your
judgment
rules
will apply in my
provided a
case.
cutoff.
Rules provided a cut.
What was the tag? Why was it tagged here? This Tej Prakash doesn't arrive here.
But I made
I was not
several
very
applications also to
at that
detag.
point of
But now
I
tell us
made a couple of
something,
applications also to detag, but somehow it did not.
Well, there's an application to DTAG also.
So it was unfortunate on
Now,
my part.
why should we do this? Let's get a statement of facts from the High Court, what actually
Yes,
happened.
No, I'll do it.
He's really concerned with questions 8, 10, and 23 of paper 2. You know, the easiest thing for us as a constitution bench is that, look, we'll send it to 2 judges, but let's find out whether there's something worth arguing, then we'll do that, you know, then. Now tell us this, you'll tell us in 2 minutes what the facts are.
Also, the counter affidavit, which is I have inherited the brief, actually does not address, apart from saying there is no procedure for re-evaluation. So therefore, we can't entertain a request for re-evaluation because as per law laid down by your lordships in Maharashtra State Board, there is no provision for re-evaluation. So now he has filed a writ petition where your lordships will then have to see whether what his allegations are, that his question paper 8, 10 and 23 are marked 0, despite the fact that his answers were correct or even have some substance. So, I mean, he can show me the question paper. If I find that, yes, there is substance, Milos, then of course I'll inform your lordships, yes, there is a prima facie case.
2015, Mr.
16,
Sharma.
15, 16,
Sir,
18.
I am
Sharma,
already
otherwise-
a judicial officer.
Mr.
I
Sharma.
was selected in the subsequent examination.
Sharma,
I
just
am
see what
working
my
as a
brother
judicial
said.
officer now.
He's already working
On aggregate score, you come below.
Only 2 marks, by 3
Correct.
marks only.
On aggregate score, you come below, meaning thereby your merit would not sort of.
Only by 3.25 marks.
Subsequently, I think
Only by
You're
3.25
already,
marks.
you're
If
already
I
in
get
service.
two- I'm so sorry, 2.25 marks. If I get one mark each in all these questions.
This 1 mark in a given situation could be a very big
One is a
difference.
world of a difference.
No,
It's not just,
but
you
one
can't
needs
just sort
to
of.
see
Discussion.
what are my answers.
Which year did you pass after the next?
2017.
17.
No,
You made it now.
17
Not the
now.
seniority would be affected. I would get the benefit of the seniority.
Even if
That-
we establish,
Seniority, now we are not
those who have
doing
been working.
So we'll say that, so the petitioner, though the petitioners, both matters, right?
One. Second one is different.
All right.
Second
Though,
one
501.1 mein kar lo.
One yesterday's
So the petitioner did not qualify for the, in the selection process for district judges through direct recruitment in 2015-16. It is common ground that he has since qualified in joint service in the subsequent batch of 2017.
Recruitment of 17. May have got appointed in 18, if I'm not mistaken.
Stop. In view of the fact that the petitioner has joined service after being recruited in a subsequent batch, no case for the exercise of the
Not
jurisdiction in
when these
Article
questions
32.
are required to be considered, not it would be
Okay.
most
In other
appropriate.
cases.
Because the High Court cannot brush aside my answers just like that. These answers are reasonable.
the
One
question-
has to see.
But
Somebody is
assuming you're right,
accountable
we
here.
can't, assuming you're right, we can't give you seniority of 2000 of the earlier batch then.
No, it can be granted. If I am eligible, it can very well be because there were deficiency of seats also.
You should
All
have,
seats were not fulfilled. The advertisement was for 99 seats.
but you
There
should
were only, I think,
gone to the
65
High
or
Court first.
6 seats were filled.
demonstrated that, look, your answers were absolutely correct. You don't go to the High Court, you come in that 32 petition. You have to demonstrate ex facie that, look, my answers are correct and I'm right.
I will demonstrate, my lord. If my lord permit, I will demonstrate before my lord or before that.
But, at the end of it, look, will we now say that in 2023 that you should be given seniority of 2016 when you have already joined service?
Not if I am eligible, then it can be said.
And there's no provision for evaluation.
The habit of
Sir,
the-
even in Kerala, where we have held that the High Court decision is wrong, we have not given relief.
I understand.
kind of
I'm
reverse
live in that
process.
situation.
Can't
but in those
unsettle,
situations-
now
I
the
was
seniority of
working.
people who have joined 6 years ago. Other people have joined service 6 years ago. We can't now suddenly unsettle seniority in service.
This,
No
the
real
answer
case
to
for
this
that.
could lie in the very fact whether there were leftover vacancies of that year or not. And whether they were filled subsequently or not. So if there were leftover vacancies and they were not filled in subsequently, then my lien can come into play. If I prove my case, then in that case I can be.
Evaluation.
No, Mr.
There is that
Sharma.
material time.
We'll consider.
The principles of justice, my lord, this is against
No, Mr.
totally
Sharma, we
entirely.
can't- now we must also look at the concerns of
And
the
that's also
service.
by a high court, my lord.
It's in 501.
This calls for interference, my lord, with deep.
What's the other one?
great
501.12,
Respect, sir.
the High Court had amended the rules and provided minimum marks in the interview. So, and that rules are in substantive challenge as being contrary to SETI Commission. There is no rules. Rules of the game have not changed during the selection process. So, advertisement and the rules provided for minimum marks, and they have challenged the validity of the rules being contrary to SETI Commission. So, I'm not sure why it is here,
Like that.
but this is the substance.
We'll
challenge.
examine it.
Let me kindly post it before a two-judge bench. It would be most appropriate, my lord. I will plead my argument before.
The issue which has been raised 𝐀𝐓𝐕 𝐍𝐞𝐰𝐬 𝐂𝐡𝐚𝐧𝐴 does not arise in the present case. Full stop. The petition is detached from the
Grateful.
batch of matters and shall be placed before an appropriate two-judge bench by the registry at an early date.
Let me fix some time.
No, this is 501.12.
1-2.
Milord, in my case,
No, no, your matter is 501.12.
Milord, I respectfully
Justice
submit only one.
Dictated the order very softly.
To hear it, Milord.
No, no, no.
Milord,
Anyway, now
the
we'll take
only
up
decision that
Rajasthan.
has to be-
Now we'll take up
Milord, just
Rajasthan.
one last submission. The only situation that has to be seen by this honorable court at this stage, Milord. What were the leftover seats at that time which were not, completed? And then whether they were fulfilled in the subsequent years or not. There are vacant seats for that year. So it is not as if that I will
Not giving
overrun
notions.
someone.
We'll not give notional scene on this. Yes. Rajasthan now. Rajasthan, who's
But
appearing
one
in
thing
Tej
can be
Prakash
added,
Pathak? Tej Prakash
Milord,
Pathak.
Just one thing can be added, Milord, replicate the very stance taken by the High Court in this matter.
All right. Tej
This
Prakash.
requires Milord, consideration.
All right. Tej Prakash Pathak now. Dr. Bhardwaj, what are the facts here?
Lordship.
This is
What is the item number?
The reference order that
This
clearly
is-
captures the facts also. So if you
Reference
look,
order.
2009-10.
9, 10, 9 selection is of 9.
Lordship.
And for translators, who
Lordship, I will just explain if my friend he allows.
501.501.
501.
501
1.1.
501.2, Lordship, I am appearing for.
501. 501. 1 point?
Tarun Kumar and Tej Prakash.
All three, the first three.
501.9, yes.
Lordship, I have no idea about the third one, but yes, I'm appearing in two matters, Lordship.
501 and 501.9.
9 and 10.
She's appearing in 501.9.
Yes.
1 and 9, I'm appearing, Lordship.
Mukesh and Jain is same.
Same.
Same
Same
is
selection,
there, Lord.
all same.
And what about, all right.
Only 3 matters are there, Lordship.
Right. Now tell us what the facts are.
Lordship, the notification, it had come in 17/9/2009.
17?
9/2009. An exam date was 19/12/2009.
What was the notification for? For holding the exam for?
Lordship.
For translators.
It was for employees who were actually working as a judicial clerks, UDC, in Rajasthan High Court. They were already in services, Lordship. And this notification for those employees who were already in the job and just to shift, promoting to the
This was for in-service employees.
Lordship, 21 eligible of employees were appeared in the test held on 19/12/2009. There were 13 vacant posts of translators, which was issued on 17/9/2009. Applicants applied as per eligible qualification, which was possessed by them, which was only MA in English, Lordship.
24/7/2.
Can I read
Go
notification
ahead.
of
Just tell us,
2009?
give us the date, give us the dates.
Lordship,
After the
dates is
advertisement, what
fine,
happened?
still I want to go.
That's the most important thing. Just tell us the dates and we'll go to the law.
2009 that I've already.
24.
17/9/2009, which was a notification, which was actually the Rajasthan High Court Staff Service. Applicants were invited for giving performer for the recruitment of 13 vacant.
Right, you
posts of
told us. And 21 appeared on 19/12/2009.
Lordship.
Then
And Lordship, then the result was declared
on
on 22/2010.
22/2010.
Lordship. Lordship, till now, we were not aware that the rules were changed one day before 19/2/2010, which we came to know actually when once we filed writ petition before the High Court. And there when the counter affidavit was filed by the respondent,
19th
It was
February. 19th, your results were declared on
19th
20th.
February 2010, the
19th,
notification.
they have imposed the 75%.
75%, Lordship, which was not even there, the
Right,
minimum
right,
and maximum, nothing was explained. It was for translators, which was actually to Hindi to English and English to Hindi. That was the only test prescribed in the 2009 notification. Kept vacant, only 3 were taken. Lordship, the employees who were, actually, they had appeared in these examinations, which were my petition, we all are petitioners. They had scored 71%, 69%, 68%, 68%, 66%, Lordship.
How much? 71%?
71%, 69%, 68%, 68%, 66%, 57%.
Below 75.
Lordship. And Lordship, these were the marks which were actually they got, which they were not even informed, even till when I filed my writ petition, I was not aware. When I
So
filed
your
my
contention is
RTI,
now those who have been selected,
Lordship,
those who, was there a Viva? Was there a Viva here?
Lordship.
There was a Viva here or no?
No, Lordship. It was only written examination.
Only written exam.
Because it was for
But
the
you were
translators.
75% minimum.
Lordship.
But
that
those who were
was
selected,
one-
those who were selected all got, 3 people who were selected got more than 75%.
They got Lordship.
And 10 persons
Lordship.
who were not selected at all
Lordship.
were all below 75%.
75%.
Were they
got
bound to fill up all the
75%.
posts? Were they bound to fill up all the posts?
Lordship, what I am saying, had I been knowing that I have to prepare in such a manner that it is a competitive examination, I would have
You are
prepared.
starting from the stage of preparation.
Lordship, this is against Article 14, Lordship. I am not
It is
given a
not
chance.
into that apply.
Don't even
They were
know.
not bound to fill up all the posts.
No,
So forget the fact that they laid down the 75% criteria later. They were not bound to fill up all the posts. They said, we'll take the first 3.
Lordship, may I read the reference?
Not a case of
order?
a change of the rules of the game in that sense.
Lordship. And Lordship, I want to read.
See, in the earlier case, for instance, the Kerala case, what happened was,
Lordship.
yesterday, which we heard, because of the fact that there was a change in the rules of the game, then though these people who were excluded, they had higher marks in the aggregate, they were still not selected because they didn't get the minimum marks in the interview.
Lordship, in
That is the problem.
Lordship.
Here, all of you are anyway below 75%. Merit,
They just stopped at one particular
Only
point.
one line. There's in the other cases, there was a revision in the merit list because of the change. There's no revision of merit list. It is still the same. Top 3, top 5, 75%, above 5. That is how it has been done in this case. So
Lordship.
there's no change in the merit list in terms of preparation.
No, there
So
was
that is what.
No.
In all other cases, there would be a change in the merit list because of that introduction of qualifying marks. That is the
Lordship,
distinction.
I want to submit, Lordship.
It was very straightforward. Okay.
Lordship, 2002 rules I have filed, Lordship, and I have given the copy also. Lordship, earlier it was 75% only, and why? Lordship, it
Pertains to
Lordship,
selection
Lordship, it is very important. I have
conducted
waited
by
so long.
the
Just one
Rajasthan
minute.
High Court
I am heard.
in
We
2009,
have seen that.
2009-10 for appointment of translators.
Lordship, may I read one reference order? Lordship, this much chance
Yes.
I should get,
Dr.
Lordship.
Bhardwaj, you've read the reference order, but the point of the matter is this.
Lordship.
Your case is that after the examination was held,
Lordship,
they decided to have a cutoff of 75%,
Lordship.
and therefore there's a change in the rules
Lordship.
of the game. And
Which was
therefore,
earlier again 75% in 2002, and again they had come and changed in
Right.
2009.
there was no cutoff.
No cutoff.
There was no cutoff
Lordship.
when the advertisement was issued. Now, what they did was they applied a cutoff of 75.
Lordship.
All right, they took the first 3 candidates and then didn't fill up all the 13 posts. They just filled up 3 posts and didn't fill up the remaining 10 posts. There are 2 others. The basic answer to that they're not bound to appoint everybody at all. Second, you see, what we try to tell you as a difference, or possibly you didn't realize that because you were not here in that matter yesterday. In the Kerala matter which we dealt with yesterday, they decided, the rules provided that the selection will be made on the aggregate marks in the written examination and the interview. These petitioners who are before us yesterday said that you applied a cutoff for the interview. So though we had higher marks than the selected candidates in the aggregate of the written plus the interview, we have been excluded only on the basis of the fact that we did not score the minimum marks in the interview, which requirement came in later. So there was a revision of the merit list. Here, all that has happened is that they said, look, we will not take anybody who has less than 75% marks.
Now, Lordship, what
I could have
happened
said
in
top
next
3
year?
also. I could have said top 3
next-
also. Instead
No.
of saying 75, I could have said
Then
top.
what happened? Next year again they took the exam. They kept 75%. Nobody cleared the exam. 0. Nobody was taken.
That is what the
Then-
translator is an important post for us.
to
We have the right judgment that have to be
that
translated. There are so
nobody
many things that have to be
can-
translated.
take
Dr. Bhardwaj, this touches the first point you made,
Lordship,
that you will have to prepare harder.
Lordship,
This is the first point that you made.
Lordship,
That's why.
Lordship, it is just a thing. Maximum, there is nothing. You can come again because they did not get on 75%. That was the only year. Lordship, that was the only year when, that means only my batch, I am suffering, nobody else. My next batch is lesser than me and still they are on the post, Lordship. Test of arbitrariness, Lordship.
Full stop. The selection was for in-service candidates. Full stop. The notification for the examination
Lordship,
was
we
issued on
apologize.
17 September 2009 for a total of 13 posts. Full stop. 21 candidates appeared at the examination on 19 December 2009. Full stop. The result was declared on 20 December 2010. Full stop. The grievance of Dr. Ritu Bhardwaj, learned counsel appearing on behalf of the petitioners, is that initially on 24 July 2004, the cutoff, which had earlier been prescribed, as a consequence of which, on the date of the advertisement, there was no prevailing cutoff for the written